So welcome to our first Know Your Rights Fair Housing session. My name is Ann Hinterman. My pronouns are she, her, hers. I am the Director of Housing and Community Affairs for Alderman Cappleman's office. And I am joined this evening with a delightful group of panelists. I'm so excited to share this information with you. We will be talking about evictions and how COVID-19 has changed the evictions landscape right now. A couple of pieces of housekeeping. We're going to be using the Q&A function for this webinar. So if you have questions that you'd like to ask the panelists, go ahead and type them into the Q&A box and we will read them aloud so that our panelists can answer them. We are recording this session and we'll be posting the link on our website so you can always review this information in the future. And attendees are muted and your cameras will remain off, so you don't have to worry about inadvertently showing up on that recording. So for the first exciting kind of surprise addition to this evening's program, we have Michelle Gilbert, who is the brand new legal director for the Lawyers Committee for Better Housing, where she is right now heading up their new eviction prevention program. So I want to turn the floor over to Michelle so she can describe that program.
Good evening, everyone, and I appreciate the other panelists allowing me a few minutes to talk about what we're doing. We're pleased to announce that we have a grant from the City of Chicago Department of Housing to staff an 11-attorney COVID eviction prevention project. And our goal is, as the name implies, to prevent evictions. I've always felt like the best eviction defense was preventing one from even being filed. We have, of the 11 attorneys, we have 5 who are working on negotiating between landlords and tenants to resolve disputes, including non-payment of rent. Part of the grant includes rental assistance. So we're able to work with our social services staff to apply for various different emergency rental assistance programs and provide grants that go to landlords to help protect tenants. We have a couple of people who are defending evictions that have been filed. For the most part, the Governor Pritzker has entered an executive order that prevents evictions from being filed in the state of Illinois, except for specifically proven instances of public health threats. So someone who is engaging in criminal activity. But a few evictions have been filed anyway, and so we are filing motions to dismiss those cases. And then finally, and unfortunately, and I understand that there is a lot of hard times and frustration out there, but some landlords are also either illegally locking out tenants, literally changing the locks, or cutting off utility service. And we are negotiating with those landlords, working with the Department of Housing, the Corporation Counsel Office, various aldermanic offices, the Chicago Police Department, to help people regain possession, and then also working to negotiate, and in some instances using rental assistance as well. So I'm happy to answer any questions about our program. We've sent to the Alderman's office some flyers about how people can access our services. You can call to our main intake number, which is 312, and I'll type this into the chat when I'm done talking, 312-347-7600, or visit our Rentervention platform, which is an automated system where you can get some tenant information as well as make an application for legal services. So, and like I said, I'll type both of those numbers in the chat function. Unfortunately, because of COVID, we can't answer the phone directly. All of our staff are working remotely, but people who need legal assistance can leave a message. We have staff who speak Spanish and English, and so we can return calls and do direct intakes, both in English and Spanish. And we have other access to other services, language services. We have a pretty high income level. I don't think anyone who has COVID impact, economic impact, is going to not qualify for our services. And we have no legal residency requirements. So we don't ask about legal residency or citizenship. I'm happy, like I said, I'm happy to answer any questions about our program or about the eviction moratoria. Thank you again for letting me pop in and give you that information.
Thank you so much, Michelle. We really appreciate you being here. So before we get started with the rest of our presentation, we have a couple of questions that we want to ask our attendees. We're going to put up a poll, and this is to collect information because this program is brought to you by a grant funded by the City of Chicago, and so we have to collect some demographic information. So we are going to go ahead and launch that poll now. If anybody is calling in, you may not be able to respond to this. So if you would take a moment to choose the responses that best match your participation here. If the first question asks if you are a tenant, a landlord, or property manager, or in some other role. And our second question is, do you live or work in the 46th ward? Yes, no, or I don't know. Okay, so if everyone has had an opportunity to respond to that, we'll go ahead and close that poll, and then we will get started. So our panelists this evening are Professor Michael Seng, who is a professor at the University of Illinois Chicago John Marshall Law School. He's also the director of the John Marshall Fair Housing Clinic. And Lewis Powell, who is an attorney in private practice specializing in evictions. He's a former adjunct professor of the Fair Housing Clinic. Thank you both so much for being here, and the floor is yours.
Okay, and it's a real pleasure to be here, and particularly in the 46th ward, which where a lot of things happen, and I think you're doing a great job in the ward. Let me explain a little bit about the Fair Housing Center and clinic that we have at John Marshall, and then I want to just give a general overview of the Fair Housing Act and how the pandemic and in some ways the Black Lives movement has impacted our work. And then Lewis, who's a lawyer, will talk more specifically about the eviction process. And then we will, of course, want to leave plenty of time for questions and answers. But the Fair Housing Center and Clinic at John Marshall, the clinic represents anyone who has been the victim of discrimination in violation of the Fair Housing Act, which is a federal law, the Illinois Human Rights Act, or the City of Chicago Human Relations Ordinance. And similar to the Lawyers Committee for Better Housing, we have no income requirements. Anyone who is claiming discrimination, and that could be by a tenant, it could be by a person who's buying property, it could be by somebody who's already a resident in the property. It can concern any aspect of properties, including financing, mortgages, retaliation. The Fair Housing Act is very broad. When I refer to the Fair Housing Act, some people think, well, that means that I've got to be treated fairly. That's a little bit of a misnomer. What the Fair Housing Act does prohibits discrimination on the basis of 7 protected classes: race, color, religion, national origin, sex, disability, and if you have children under the age of 18 years old. So if anybody is experiencing problems because of any of those factors, then we're funded by HUD. We also get training funds from the City of Chicago, Department of Housing. So we can come in and train people. We can also represent people in court and administratively who are the victims of housing discrimination. And again, anybody can be the victim of housing discrimination. It could be a tenant, it could be a homeowner. Landlords could, in certain cases, be victims of housing discrimination themselves in terms of financing, zoning problems, and all of those types of things. So our practices are pretty much restricted to those types of discrimination areas. I might also point out that discrimination in Illinois and in Chicago is defined somewhat more broadly. It may, for instance, in Chicago, a source of income. So people with housing vouchers may, if they're being discriminated against, may have an action, and we would be able to represent them. So housing discrimination is really the essence of what we're all about. And the pandemic and the Black Lives Matter movement has played a very important role in the Fair Housing Act, the enforcement of the Fair Housing Act, state and local laws in terms of discrimination. And there's a number of problems, and as I say, Lewis will get into the problems more of eviction, that type of thing. But I'll talk about other problems that may come up that we're seeing and other people around the United States are seeing as a result of the pandemic. First of all, as I mentioned, the Fair Housing Act prohibits discrimination on the basis of sex. And sex is defined very broadly under the Act, and in fact, under state and local law, and given recent federal court decisions, it would also cover sexual orientation, sexual preference, any kind of discrimination against the LGBTQ community would be covered by discrimination, certainly locally, state, and presumably under federal law now also. But sex discrimination can also apply to sexual harassment. And I bring up the question of sexual harassment because that is a major area where complaints are being filed as a result of the pandemic. And that makes sense. People are home sometimes 24 hours a day. And so people are facing financial problems in paying their rent, problem in meeting their payments, getting things done. And that makes particularly women, but again, sexual harassment can happen to anyone, vulnerable to sexual harassment. And sexual harassment under the law includes both the what we call quid pro quo harassment, where you are told that if you want certain services or certain benefits, that you will have to reciprocate. And that type of behavior where someone is conditioning your rental conditions or your living conditions on your providing sex violates the Fair Housing Act. The other thing is hostile environment. So even if there is no quid pro quo asking, if you are in a situation where you feel uncomfortable because of um, your sex or gender, where the landlord or a maintenance man or somebody may be coming into your unit and making you feel uncomfortable, that type of thing. That is also protected under the Fair Housing Act. And the third thing that would fall under the problem of sexual harassment is domestic violence. That's a very different thing than we normally think of as sexual harassment. But if you are a victim of domestic violence, either by a husband, by a boyfriend, by anybody, the both Illinois law and federal law say that you are protected by the fair housing laws. And the housing provider may not evict you or retaliate against you because of your victim status. The Illinois law talks about if you're under a protective order of the court. Federal law is interpreted even broader than that, that if you are a victim of sexual harassment and you are being retaliated against by a landlord or other housing provider because of that fact, that would be illegal under the law. And those situations are coming up. In domestic violence, we see, and there are studies being shown, that because of the emotional stress that people are under as a result of the pandemic, many more cases of that are taking place. So again, that is something that is protected under the law. It's protected by the Illinois Human Rights Act, Chicago Ordinance, and the Federal Fair Housing Act. You can make a complaint to the Fair Housing Clinic, and let me give you the phone number for that. It's 312-786-2267, and they can advise you on what to do, and that is clearly a matter that is arisen and is getting attention now as a result of the pandemic. The same thing in some ways can happen with families with children. If you have younger children and they formerly were at school, but now they're around the house 24 hours a day, that may be causing problems, and landlords may not like that. So again, remember that families with children are a protected class. And if there's discrimination because of that fact, now again, if your children are causing a disturbance, if they're damaging property or something, that's a different matter. But just because children are around or living in a unit does not offer an opportunity for a different treatment. There's also circumstances, and there are reports, particularly by Asian Americans, of being discriminated against as a result of the pandemic. So any type of race, national origin, color discrimination can arise as a result of the pandemic. And then, as I mentioned, one of the other protected classes is disability. And we have not seen a lot of cases, but theoretically, and we've heard of situations, for instance, where health care workers or other people who are around persons who have contracted the virus have been discriminated against. If that is the case, the definition of disability is broad under the Fair Housing Act. It doesn't cover everything. You've got to have some sort of a physical or mental impairment that limits a major life activity. Again, if you test positive that may or may not indicate that you're disabled. But again, if you're confined to your unit, you can't engage in normal life activities. That may, there's no court decisions on that, but may indicate that you're a person with a disability. But the act even goes further than that. If you're regarded as having a disability or have a history of disability. So if you contract the virus and then have recovered, but landlords are worried that you might spread it to other people, you may be regarded as having a disability. So those are tricky questions. But again, if people are experiencing any discrimination on that, there is a landlord defense that if you're dangerous to the health of others, that may be grounds for excluding someone. But that cannot be based on stereotype. It's got to be based on actual facts. So again, there's a lot of things that are arising as a result of the pandemic that I think it's important to be aware of, apart from the eviction problem and the other problems that you may have in paying your rent. The other thing that I just wanted to emphasize is the Black Lives Matter movement, and all of that emphasizes the real role of race discrimination, national origin discrimination, discrimination against minorities in our cities, in the United States. And the Fair Housing Act very broadly prohibits discrimination, very broadly prohibits segregation. It requires recipients of federal money to affirmatively further fair housing. And we're seeing, as a result of housing segregation in communities, that people of color are more directly affected by the pandemic. They are more likely to become ill. Medical service is less likely to be available to them. We know with jobs, education, all of those types of things, that the impact that the pandemic is having on those issues. And a lot of them are traceable to housing discrimination. So again, those are issues that we're concerned about at the clinic, at the center. And we'd be very happy to talk to any of you who may have concerns in that area and would like some help. Now, my expertise is not in the area of evictions. That is an area that Lewis is more of an expert in. So I'm going to turn this over to Lewis for him to talk a little bit about the effect of the pandemic on landlord-tenant relations.
Thank you, Professor Seng. I appreciate the opportunity. I'm going to speak briefly on an overview of pandemic issues, but also I want to stress toward the end of my presentation the need for negotiation. And I hope that the audience will, whether you're a landlord, housing provider, or a tenant, will take what I have to say at heart in terms of negotiation. To the best of my knowledge, Governor Pritzker on March 9th entered the first moratorium. And essentially, he's been extended it roughly every 30 days. The general consensus is that the moratorium is going to probably continue until the end of the year. Now, what are we talking about the moratorium? The moratorium simply is stating that you cannot file an eviction, a residential eviction, unless you can demonstrate with good faith that the tenant is a danger in terms of health, safety, welfare, and criminal activity. Other than that, you cannot file the eviction. That's basically the Reader's Digest version of the moratorium. You can file a commercial eviction But again, under Governor Pritzker's moratorium, which he's extending it every 30 days, you cannot file a residential eviction, period, unless it falls in exception of health, safety, welfare, or criminal activity. March 27th is when the CARES Act came into effect. And the CARES Act effect, most eviction attorneys are interpreting it that if you have a federally backed loan for any of your properties, it doesn't have to be the subject property in which you're trying to file an eviction, but any property you have, if you have a federally backed loan, you file under the CARES Act. Also, the interpretation is, and it doesn't have to be the subject property in which there's a payment problem with eviction. If any of your properties you have or have ever had a tenant on some federal subsidy. The CARES Act went into effect March 27th, and essentially it was a 120-day time period. Under normal conditions, let's just talk about normal conditions. You issue a 5-day notice. If the tenant is not paid rent within 5-day notice, then after the 5th day, you can file your eviction. Under the CARES Act, when it went into effect, the earliest that you can file, the earliest that you can serve the notice of termination was actually July 24th. And bear in mind, it could not be a 5-day notice. It has to be a 30-day notice. The CARES Act specifies that the first notice that can be served would be the earliest would be July 24th. And again, instead of a 5-day notice, a 30-day notice. Meaning, essentially, the earliest that you can file an eviction will be August 24th, provided you serve the notice on July 24th. Okay? That's the CARES Act. The exception to that, if there's an affidavit the landlord had to attach to the complaint stating that he or she is not affected by the CARES Act, meaning they don't have a federally backed loan or a subsidy that is federally backed, like Section 8 or something like that. The nuances of pandemic issues are somewhat complicated, but I'm going to make them simple for you. In terms of the city of Chicago, the city council passed an act called the Tenants Know Your Rights. Now, bear in mind, everybody knows about a 5-day notice, but the Tenants' Rights Act, which actually, I believe, was actually drafted by the Department of Housing, it extends the 5-day time period that you have to pay your rent. It adds an additional 7 days where the housing provider is obligated to at least engage the tenant in a discussion in terms of how to possibly settle it and avoid eviction. Recapping, the general consensus of the eviction lawyers is that even though the CARES Act went into effect on March 27th, saying that you had 120 days where you had to wait to file an eviction, we are interpreting that it's still in effect. I'm advising all of my clients, instead of 5-day notices, to still give the 30-day notice, even for not non-paying the rent. I'm instructing my clients even for a violation such as unauthorized occupants, criminal activity, which under normal circumstances you can give a 10-day notice. I'm instructing my clients to give a 30-day notice. In terms of the ramifications of the court system, it is to the housing provider, i.e. the landlord, as well as the tenant, to try to come to some type of compromise. And the reason it is this. Right now, we have a bottleneck in the court system in terms of evictions. I have evictions that were filed pre-COVID, and they're still stuck in the system, meaning that the clerk's office is automatically continuing them to keep on continuing it. The clerk's office and the judicial system are trying to encourage people, the housing provider, i.e. the landlord, and the tenant, not to go to court. You can go to court if you want to, but they really encourage you to participate by Zoom, and they're making it very easy. You don't necessarily have to do the Zoom app. You can call in the number and still get in. It's just the judge cannot see you. So they're trying to make it very easy, very accessible for the tenants as well as the attorneys to not go to court. In terms of the bottleneck, I've gotten judgments 3 or 4 months ago, pre-corona, pre-pandemic issues, where the sheriff office, again, under the moratorium of Governor Pritzker, is not physically evicting anyone. You can only have the sheriff physically evict someone. I mean, putting their position out on the street, which is unfortunate, unless you can prove to the court satisfaction that, again, that the tenant is a danger to the health, safety, and welfare of the building, as well as criminal activity. It is to the landlord and the tenants' best interest to try to work a deal. Some of my clients are offering reduced rent with the caveat that eventually you have to catch up. Some rent is better than no rent. We have a lot of landlords, small landlords, that are barely making it. Their back is against the wall. There are some programs. I know IDA has a program, but their sources are limited in terms that the tenant can apply to get money directly to the landlord. Some of my clients have been able to buy time with their mortgage lender. Not all of them, but some of them have been able to buy time with the mortgage lender. The advantage to the tenant is very obvious. Eventually, the moratorium is going to have to end. It cannot go on indefinitely. And what we think is going to happen is that since there's a bottleneck in terms of the court system, and since there's been a prohibition for all intents and purposes of filing eviction, there's sometime next year there's going to be a tsunami in terms of a lot of evictions being filed. So the advantage to the tenant is to try, if they can, to work something out. Work something out by trying to get some of the subsidies that are available. Work something out by trying to negotiate a partial payment of rent. Or the worst scenario, if nothing can be worked out, trying to come out with a reasonable move out date. Most tenants are aware of the moratorium. Most tenants are aware that for all practical purposes, no one is probably going to be evicted this calendar year, with the only exception of health, safety, and criminal activity. So it will behoove the tenant to try to work out an agreement with the landlord. They move out in a reasonable time period and avoid having an eviction on their record. As we all know, sometimes having an eviction on your record could be damaging because most people are doing some form of a background check. So I always encourage tenants, if they can work a deal to move out in a reasonable period of time and have in the court order that the file is sealed, then that way that would not be a blemish on their records. So that is an overview, because we're looking at the landlords, we're looking at the tenants, we're looking at a bottleneck in the court system, we're looking at a situation where realistically no one is going to be evicted physically this year unless they're a danger to health, safety, and welfare. We look at the city council ordinance, which says that the landlord and the tenant are obligated to at least engage in a discussion in terms of how they can settle it. Any questions?
Yes, we do have some questions that have come in through the chat. One question that I have before we move forward, if somebody were not able to pay their rent right now, maybe they have been making ends meet, they've been dipping into savings, they've been paying their rent every month since stay-at-home began, and right now, we're coming up to November's rent, they can't pay for the first time. Would their landlord be able to file an eviction right now?
No, unless, just to recap, the house provider or the landlord can give a notice. And again, most of us are saying still stick with the CARES restriction instead of a 5-day notice. We're talking about non-paying of rent. Still give them a 30. That's most of our opinion. Some people may differ, say you go back to the 5-day notice. But the answer is that the housing provider can give the tenant a notice, but for all practical purposes, the housing provider will not be able to file the eviction in the very near future. And a caveat, some money is better than no money. As Professor Seng knows, there's black letter law saying once you give a notice of termination, if you accept any rent, there's two schools of thought. The majority school of thought is if you pay the full amount in 5 days, we just use 5 days example, the landlord has to take it. There's another school of thought that if you pay after 5 days, which is really black letter law, with the landlord's mercy. There's another school of thought that says if the landlord accepts rent after 5 days and it's a partial payment, unless the court has given the landlord permission to take use and occupancy, he's essentially or she's essentially reinstated the tenancy. So the more that tune is that the tenant should be in constant communication, letting the landlord know what their employment situation is, and trying to see will the landlord accept reduced payment. And under the circumstances, I think a substantial amount of landlords will take the position that I'm going to take some money rather than have no money, maybe for a limited period of time to keep some type of cash flow to make some type of payment toward my mortgage. That is my opinion. I hope I answered the question.
Mm-hmm. So if somebody wasn't able to pay November's rent, they would not be able to be evicted right now. Their landlord would, on your advice, have to give them a 30-day notice to become whole on the rent.
Right.
And what if they were not able to pay? The 30-day notice has expired, they weren't able to pay, or their landlord wasn't willing to accept partial payment. What could happen after that?
The circumstances are now quite plain. Governor Pritzker is going to keep on extending that moratorium. I neglected to say the CDC, Center for Disease Control, has issued their moratorium. And Professor Seng, you are my constitutional law professor. There is an argument out there that CDC is overstepping their boundaries in terms of states' rights. So that's another argument, whether it be the CDC moratorium, but the CDC moratorium says no evictions, period, into December 31st. But there's a constitutional argument saying that is not applicable. But for all practical purposes, we know Governor Pritzker is going to keep on extending it. So I do both landlord, I represent mostly landlords, but I do represent tenants. But for all practical purposes, no one is going to be evicted this year, period, unless the landlord in good faith can advocate that the person is a threat to safety, health, and welfare or criminal activity.
Thank you.
Yeah,
okay.
I think it's fair to say that any of these changes in the law and everything are probably subject to legal challenge.
Absolutely.
Nothing is terribly certain. There's you always have to balance the rights of the tenants versus the rights of the property owners. But I think it's fair to say that probably most judges in these situations are going to be very practical. And Lewis's advice to don't rely on strict legal principles, try to work this out, is probably really very good advice.
Absolutely.
So here's a question from someone who works in a social services agency. They said that some clients have received 5-day notices from their landlords despite the moratorium and the CARES Act. What is the best course of action for them to take?
The best course of action is to get a lawyer. Now here it's up to interpretation. As I said earlier, my interpretation as well as other eviction attorneys, because the CARES Act technically went from March 27th to July 24th, meaning that on July 24th, and some landlords counting the days to give a 30-day. Some people, I'm not surprised that some people are going back to the 5-day notice. My position is better safe than sorry, meaning giving a 30-day notice as opposed to five-day notice. In this situation, I would encourage them to go to Lawyers for Better Housing or Legal Aid Foundation or any other, legal advocacy agencies, and they could probably keep the landlord at bay. But the bottom line is they can't file it again unless it's safety, health, or violence, criminal activity.
Great. So some other folks have questions about what can they do if their landlord is refusing to engage with them. They've tried to contact them. They're not getting any response from the property manager. They can't get any answer on negotiating about the rent, and their landlords are refusing to talk to them about renewing their lease. So it would put them in a position potentially of going to a month-to-month lease.
Unfortunately, the Know Your Rights ordinance means well, but essentially it's saying that you are obligated to engage the tenant in trying to come up with some type of way to resolve the situation. The ordinance cannot force the house provider or the landlord to accept a reduced payment, to not let them pay at all. It's just, they just don't have that authority. Because actually, I think that'd be unconstitutional. They just don't have that authority. But in that situation, I will certainly try to get on paper, which is better than nothing, saying I'm trying to engage you. I would like to still talk to you about a reduced rent, so forth and so on, and pay it at the back end, as we say in the business. It is worth them trying to do something.
And it's always good if later you are appearing in eviction court, you're standing before the judge, if you have a paper trail to be able to pull that out and say, Judge, I've done everything that I could possibly do. I've sent them notices, I phoned, this is my record of what I've done. It may not work legally, but psychologically, that's going to have an impact on what happens, I think, in court.
Absolutely.
So another person asked, does the moratorium apply to a tenant who is working and has income, but is just refusing to pay rent and is now a holdover with no lease?
Yes. Unfortunately, there are some people that are taking advantage of the system, that are gainfully employed and see the opportunity to not pay the landlord and use that rent money for something else. So unfortunately, the answer is yes.
Is there any relief that anyone knows about for landlords who have increased rent during this time period?
In terms of a lease is a lease, which is a contract. But technically, at the lease over on its own terms, if less, the tenant is basically a month-to-month tenant. Now, one thing has changed with the fair notice ordinance. It used to be in stone that you give your tenant 30-day notice prior to the end of their lease, that their lease would not be renewed. That used to be the black letter law, but as of July 14, 2020, is 60 days for tenants who have been in an apartment for 6 months and 3 years. I'm just reading it, which is as quite honest with you, this has some housing providers fit to be tied, because everyone was used to, I give you a 30-day notice that I'm not renewing your lease and you're fine. But now it's 60 days for those who have lived in the current apartment for 6 months and 3 years. 120 days, which is really upsetting people, 120 days for tenants who have lived in their current apartment for over 3 years. And some people see that's pragmatic, but basically what it's doing is allowing people to have more time in terms of being noticed properly. But when you think of it, the pandemic really hit in March. it's fair to say, in terms of where we saw the mass effect. So I don't think a lot of housing providers are saying, well, you know, this didn't come into effect until July 14th. So really, a lot of landlords are really stuck with tenants for a while that have refused to pay rent, who have refused to sign a new lease. This really puts the landlords in a bind because now it's forcing them to deal with tenants longer than what they normally would after the end of the lease ends. So it's really this is designed clearly to give tenants more time in their present unit.
Here is a question from an attendee. I was furloughed for the last 6 months and have just learned a few weeks ago that my job has been eliminated. I've lived here for 5 years. The landlord issued a lease only for the first year I lived here. I have not had a lease since that first year. So they have been a month-to-month tenant since that first year. What advice do you have for me? Can I ask for reduced rent? What if the landlord then wants to issue a lease at the original higher rent?
Negotiation is the key. Any money is better than no money because the landlord has obligations to pay. You don't know the landlord's financial condition. If he's a big mega landlord, he or she may be able to, you know, weather the storm with a tenant or two not paying. But the typical landlord is not a mega landlord. The typical landlord is robbing Peter to pay Paul, even under good circumstances. So my advice would be to see if you can encourage them to work something out. And I think in terms of offering, you know, some money with a plan to pay more toward the end, you know, toward the middle of the lease, toward the end of the lease to catch up, I think landlords may be acceptable of that.
If
Zero is a big number. 0 is a big number, which is a lot of housing providers are getting.
If a landlord has received mortgage forbearance, are they required to disclose this to tenants if the tenants ask?
I don't think so. I haven't given any thought. This is the first time I heard the question. I don't think that you're obligated to disclose that you have gotten a mortgage forbearance. I think, you know, I think Michelle Gilbert is not on, but I think that if you have been foreclosed on, I think you're obligated to disclose that. Okay, I think again, you foreclose, you're obligated to disclose that. But in terms of you getting some type of forbearance, I don't think you have to. I don't think that's public information.
Some tenants have been trying to, as part of their negotiation, they've been trying to take advantage of subletting units if they are no longer able to pay their rent. Some tenants especially in Uptown, live in low-income units that are subsidized. They aren't vouchers, so it's not that the rent is paid on a sliding scale commensurate with their income. They have a below market rent, like an affordable requirements ordinance unit. Some tenants have been wondering if they are still allowed to take advantage of the option to sublet if they can't pay their rent when they're living in a below market rent, but their rent will not be adjusted when they lose income. Can they still sublet?
That's a good question. And in my mind, two things come into play. Most leases will state whether or not the tenant can sublet or not. Most leases will say that you can sublet, but with the landlord's permission, allowing the landlord to take a look at the credit of the person you want to sublet, so forth and so on. But also, in terms of an affordable house component, I got it that you said they may be under, you know, reduced payment because they're in some type of program. You would have to look at the program, and I think the program will probably prohibit the tenant from subletting, because affordable housing, in my mind, is not, you know, opportunity for you to make a profit off of your subsidy. Meaning, I get to rent a property for, this makes about $300, and I can find somebody because it's in a unit that's the area is gentrifying, and I can get $700. I don't think the subsidy will allow you to do that. But then, Professor Seng knows there are some case law out there saying if we can prove on a fair housing aspect of it that you had absolutely no reason to not allow this person to sublet, there's a possible fair housing issue. But the fact that you gave me, again, looking at the lease and looking at their subsidy in terms of the rules and regulations of their subsidy.
Okay, so I shared an apartment with a roommate, but have moved downstate since March 31st because of COVID to live with my family. So I haven't lived in the apartment for 6 months. I've tried to find someone to replace me, but have been unsuccessful. And the landlord continues to require me to pay. I can't keep paying as I don't have a job and I'm running out of savings. What do you recommend?
Try to cut a deal because it's pretty black letter law. At least it's a contract. I think somebody must still be living there because I think she said she was rooming with somebody or he.
Yes.
Right. Well, the law says whoever signs their name on that lease are obligated, whether they are there or not. And what that person should try to do is try to work a deal and try to find somebody that can sublet, provided she can get the landlord's permission. But black letter law is they're still liable on the lease, even though they moved out.
Great. We have some folks who have been concerned about discrimination and believe that they are being retaliated against by their landlord, and they are members of protected classes. How much proof is required of discrimination in a case like that? This is probably a question for Professor Seng, a fair housing question.
Yeah, I don't think there's not any specific degree of proof. It's a civil case, so you've got to put on sufficient evidence to show that it's more likely that there was discrimination than not. Many of these cases, and again, I don't know what the facts are here, are determined by testing. Testing is a major way to prove housing discrimination. So if there's a way that the apartment provider can be attested, and normally that's by sending in somebody with, if you think that the discrimination is against African Americans, you send in an African American tester, you send in a white tester and see if they're treated the same. Now that will not work in every instance, but that's an excellent way of showing discrimination. Beyond that, and one thing I didn't mention is that what you can do, you don't have to get the evidence yourself. If you feel that there may be discrimination, you can file a complaint either with HUD, with the Illinois Department of Human Rights, or the City of Chicago Human Relations Commission. They will investigate. And if they find probable cause, then they will advise you of that, and they will bring the action, represent you in the action, unless you want a private attorney and bring your own. So if a person is uncertain, I would strongly recommend that they check with either the federal or the state or the city human relations commissions and file a complaint. It's a very simple process. There's no cost. You don't need an attorney, and that's the best way to determine, rather than trying to go out and gather your own evidence, which can be very tricky.
Thank you. So this will be our final question. We've had some people, now that they are working from home, their landlord knows that they're around and they're trying to come in at the last minute to do requested maintenance. And tenants are having a harder time explaining to their landlord that they still may not be available all the time if they have to be on Zoom meetings. and have their microphone on. They can't always have someone coming into the unit. And some folks have found that their landlords are getting pretty upset about this. Do you have any recommendations about how someone may be able to handle that?
Try to work it out, because the landlord-tenant ordinance is still in effect. Because in the landlord-tenant ordinance, clearly the landlord with 48 hours notice, written, text, email, saying I'm coming at a specific time to do an inspection. And I tell my clients, be specific. I'm coming at a specific time range to do an inspection and to have my maintenance person or contractor to do, needed repairs. If you're not there, I will be keying, because you can key somebody's door as long as you give them some type of reasonable notice. On an emergency situation, any means necessary. But what you're describing really sounds like routine maintenance or something that needs to be done. The house provider does have the right under the landlord-tenant ordinance to give 48-hour notice, to give a time frame to show up. Now, again, you need to be reasonable, because as folks are working, you need to think, if I'm a landlord, I want you to be working. I don't want to interfere with you making a living to pay my rent. So I'm going to try to work with you to the best of my knowledge. And if I have, our common sense is needed. If I have the repairman come on the weekend, I know people working 24/7, but if I have to have people come on the weekend to do the repairs, or the time period that may work better for you, so I don't interrupt your Zoom meeting, whatever it is that you're doing, I think as a house provider, I think a lot of people will probably try to come to some type of reasonable compromise and try not to just use the landlord-tenant order saying, I give you 48-hour notice, but I'm coming. And if you don't open the door, I'm going to key it. I think most people will be reasonable.
Yeah, the law presumes that everyone is reasonable, and we know that isn't the case, but you always try your best to work around that.
Thank you. So we had one question that came in through the chat, and I want to share the response live with everyone. They were asking, what about circumstances where their unit may be in violation of the City of Chicago heating ordinance? So this is the ordinance that requires that landlords provide heat at a minimum of 68 degrees during the day and 66 degrees overnight, starting September 15th. This goes through June 1st. They're asking, what if their unit hasn't been kept at that temperature? This is something that the City of Chicago takes really seriously.
Absolutely.
You can enter a request for an inspection through 311, or you can contact our office or your alderman's office if you live in a ward outside of the 46th ward, and we'll include our contact information in the chat. So please, if your unit is below 66 degrees at night or below 68 degrees during the day, you can ask the city's inspectors to come out and take a look at that. We have one last poll. We have some upcoming training sessions. Our next event with this same team, plus one more presenter, will be this Thursday during the day. It's about discrimination in senior housing. So if that is a topic that interests you, or if you know someone who may be interested in this, the registration link is available in the chat. And then we have some other requests that have come in, or other people that we know are available to provide training sessions like this. So we have one last poll for you. We'd love to hear what other options you may be interested in. And while that is going on, I'd like to thank our professors, Professor Seng and Mr. Powell. Thank you so much for being with us. We really appreciate you sharing your time and expertise with us today.
Thanks for the opportunity.
I'm glad you're making this available to your constituents.
Okay. So with that, we will close our poll. Thank you so much. And if you join us for another session, we'll see you then. Alderman Cappleman's office's contact information is in our chat, and we can follow up for all attendees with the resources that were provided today, the information about the Lawyers Committee for Better Housing, information about the City of Chicago Fair Notice Ordinance, and the John Marshall Fair Housing Clinic information. If you have any other questions, feel free to contact us and we will try to get an answer for you. Thank you so much. Good night, everybody.